We call to order, please, the Queen Anne's County Planning Commission for Thursday, December 11, 2025. We'll begin with the Pledge of Allegiance, please. I pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, good morning. Mr. Shelton, are there any public comments generally listed? No. All right, seeing none, we have legislation, legal matters, miscellaneous staff items.
Good morning. Stephanie Jones, Long Range Principal Planner. I just have one update for you. The text amendment that you did hear last month specific to Gunston and our growth allocation process, the commissioners did convey that to the Critical Area Commission this past Tuesday evening. That process from there everything goes to the Critical Area Commission. Their program committee will hear it at the end of February, and then their full commission will hear it then at the beginning of March. Following that, it comes back to the county commissioners and they go through their public hearing process and final decision. So it's still some time out, but I just want to at least give you guys an update as to where it stands. So without that, just happy holidays, and I hope you guys have a Merry Christmas.
Thank you.
Same to you.
Anything from Counselor on legal?
I have nothing today.
Sorry to get you mid-chew there.
That's okay. I have bronchitis, so I'm trying not to cough on everyone and everything.
Yeah, well, thank you. All right, we'll start off then with our first project, Major Site Plan SP 25-08-0158, Hinckley Yachts. Steve and John, point of contact for staff.
Okay, good morning. I'm Steve Johnson, Senior Planner with Planning and Zoning. Before I start, I do want to thank my supervisor, Rob Gunter, for helping review this project. So, as stated, we're here to discuss project SP 25-08-0158 for Hink BB Holdings LLC, who is proposing to administratively combine 3 lots to construct a 47,067 square foot addition to an existing boat storage and maintenance building, and is requesting major site plan approval. Project's located in Stevensville, south of Route 50 on Pier 1 Road as part of the Bay Bridge Marina Complex. More specifically, the site is comprised of 3 lots totaling 28.544 acres. To support this development, the applicant will or has submitted an administrative subdivision to combine all 3 lots, which will create resulting Lot 2. This subdivision must be recorded prior to final site plan signatures. Property is zoned Airport Protection and Ken Island Gateway. It's located in the Chester-Stevensville growth area, and it is also located within the Enterprise Zone and the Priority Funding area, which are not shown on your screen. This project meets all Chapter 18 landscape requirements. The property is partially located within the 100-year floodplain. There is no development proposed within the floodplain. Typically, there'd be a 300-foot shore buffer on site. However, the Planning Commission reduced that to 0 in August of 1989. I believe you may have heard this with the other 3 projects that we had on the site. Stormwater has been provided on site. DPW has reviewed and approved these facilities. They're shown on your screen in bright green on the left. There are no steep slopes, streams, woodlands, non-tidal wetlands, erosion hazard areas, or endangered species on site. And forest conservation is not applicable as the entire property is located within the IDA designation of the critical area. There is modified buffer area on site. This is everything kind of to the north of the red and white dashed line on the left side of your screen. No development is proposed within that area. However, there is a net increase in lot coverage outside the modified buffer area in which the applicant will plant 4 trees to address that increase. All critical area requirements have been met with this proposal. All airport district non-residential development standards are met with this proposal. That includes height, setbacks, floor area, impervious. With regard to floor area, the applicant is proposing a total of 66,678 square feet on site. This includes 3 existing standalone storage buildings, which you can see on your screen there, the existing boat storage and maintenance building, and the proposed addition. No single structure on this site will exceed the maximum of 65,000 square feet. The applicant is proposing 7.317 acres of impervious, and all Chapter 18 parking requirements are met. Project's required to be served by public water and sewer. A total of 1,066 gallons per day of water and sewer allocation is required. They currently have 564. They must acquire an additional 502 gallons per day, and that allocation may be approved administratively. Based off the current review, this project does meet the requirements of the adequate public facilities ordinance, subject to the conditions of approval on your screen and that were laid out in your staff report. With regard to the airport, the county has filed a petition with the FAA, the Federal Aviation Administration, which asks them to review the project to assist in determining if the proposed new structure will reduce the effectiveness of the automated weather observation system, or the AWOS. I'd like to note, this isn't to get in the way or stop this project. It's just simply a review, an additional review to ensure everything is okay, as the county is concerned with that portions of the proposed development fall within the AWOS wind sensor critical areas, and this proposed development may diminish its effectiveness. To this date, we have not received information from the FAA regarding the status of that petition. With that said, the airport manager does support conditional approval of this project, subject to the conditions that were included in your staff report and within the, just within the staff report. This is a look at the architectural renderings of the property. These do meet the TCUC design standards. I do want to commend the applicant for putting together such a good-looking facade of this building. This is pretty good. What you're seeing here on the top is the front east-facing side of the building, and the same on the bottom. A little bit more of the east-facing side is shown. Here you can see the front west-facing side of the building at the top, and the bottom shows the rear and the east-facing side. And with that, I will try to answer any questions you may have or turn it over to the applicant.
I have one question. Is this not putting the cart before the horse, not having the FAA approval yet?
Ultimately, the airport manager has recommended approval. We did ask them to be here today. They were unable to send, or, they were unable to make it. It's a fair question.
I don't think it's gonna be an issue, but I don't work for the FAA. I have flown in and out of that airport though, but, just seems like,
We can address, we'll be able to address that in our.
All right.
And I see that the number 7 and 8 under the resolution suggestions
Okay.
are incorporating
Yeah.
those.
I figured it would be.
Okay.
Yeah,
All right,
yeah.
thank you.
Okay.
Oh, we have Steve?
Yeah, that's
Any questions from the rest of the panel?
Yeah, one question. Maryland Department of Transportation has not objected, but has not given final approval. Does that mean that we're thinking about a conditional approval today, or are we expected to say, go ahead? I don't see how the project can go forward without that approval.
There is a condition at the end of the staff report.
Oh, okay, sorry.
But ultimately, state highway, we don't have jurisdiction over their requirements. I mean, maybe Lindsay can chime in, or Rob.
Rob Gunter, Principal Planner. In my time here, I think all of your approvals have been conditional, because they all have conditions they need to meet until they get final approval. And technically, final approval isn't until the plan gets signed. So it wouldn't be abnormal to have a comment that says any additional state highway comments have to be addressed prior to final signature. With that being said, also, State Highway did provide a comment 2 days ago.
December 9th.
As of the writing of the staff report, they hadn't provided. So,
I have that here if
Yeah,
you'd like
what
me
is-
to read it.
Yeah, please.
Okay, the only comment they provided was this: the previous comment that DMS and Hinckley were to meet to discuss the signal at Maryland 8 and Pier 1 Road has not occurred.
and I guess, so,
If Steve's finished, any more questions?
Sir, all set?
Yeah, Kevin, go ahead.
Kevin Sharon, DMS and Associates. With me is Andrew Barksdale, representative of Hinckley. We have a number of consultants here as well and online if there are any questions about different aspects, one of which is our FAA consultant, so we can talk about that. But just to briefly answer your question and your question before we go any further, and also Ryan Showalter is on his way, he's stuck on 213 somewhere. Prior to submitting anything to the county for this project, we hired David Perry, who's an FAA consultant and former FAA employee, and we went through the forms and submittals to FAA. They reviewed all those, took several months. They reviewed all those, and he can speak to it in more detail. But all of the structures that are proposed, they came back with a letter of no determination of no hazard. So those have been provided to the county. But even with that, the county then filed a petition, and so we're waiting on the petition. That got delayed because of the government shutdown. But from what we've been told in conversations with some of the FAA employees, they still have to do their due diligence, but they haven't seen anything yet that would change their original determination. So.
Essentially, the FAA has approved it.
Right.
And they're just waiting to decide on an additional county petition to review it again.
Yeah, I understand. The only reason I really asked the question was for your benefit, you know.
Right,
you know,
exactly,
that you have risk here that even if we approve it, it may not go forward, right?
And that's why we front-loaded that
Okay.
before we came before
Way
the county.
before,
Yeah. And then regarding the state highway, I met with DPW and they, as Mr. Johnson said, it's really not in the county's purview. We're not on a state highway. Hinckley has signed a contract with a consultant to do the design of the improvements that the state is looking for. However, this same issue came up, as you recall, with the Walt Petrie development, and we have reached out to State Highway and trying to set a meeting up. What we'd like to do is if they want that, it's basically just a change of the signal phasing. If they want that, it's from, you know, design and construction, it's about a $60,000 item. So we are going to try to meet with the state and see if we can find a way to get reimbursed for other developments that come through and use that intersection rather than just last man through the door. So we will be working on that as well. So with that, I'll go through, I don't want to repeat everything that Mr. Johnson said, but I just wanted to highlight a couple of things. As he stated, we are consolidating, so this site plan essentially will be preceded by an administrative subdivision to combine lots 2, 7, and 8. 2 is the overall marina, 7 takes frontage off of Pier 1 Road, and 8 is the one that has the existing storage building. The intent of the project is to add additional storage and workspace for Hinckley. It will not operate as a motel. It will just be for storage and working on their customers' boats.
So storage of boats that are being worked on,
Well,
not
and just
overwintering
storage.
per se.
What's that?
Not overwintering per se.
Yeah, they will overwinter.
Okay.
Yeah, they will overwinter.
Traditionally, they come in the fall, we work on them the entire winter, and they launch in the spring.
Gotcha.
That's
Well,
our
I'm just trying to
typical-
discern why you made the comment that it's not a motel.
So it's not a motel in the sense that a customer can't call up and say, launch my boat at 8 a.m.
They won't be going in and out.
They won't be going in and out.
Gotcha.
They'll stay there. And yeah, so it's not operated like the motel is on
Okay.
Kid Island.
Gotcha. Thank you.
So currently, Hinckley leases space in Talbot County and Easton, and that is, the purchase of this marina will shift all of that operation from Talbot County and Easton up to Queen Anne's County. So they've made a significant investment in Queen Anne's County. It will also, so the boats that are stored in Easton are actually hauled out here and hauled overland over the, Route 50 corridor down to there. So by changing the location of it and hauling here and storing here, each season will save about 170 trips of tractor trailer and a chase car. So, in order to get this use as a marina, we originally applied for this as just Lot 8, but because the use of marina, the definition calls for it to be waterfront. prompted the consolidation of lots 2, 7, and 8, because 2 is the overall marina, so technically now the property has water frontage and the use is compliant. So Dave Perry, as I mentioned before, he's the former FAA employee and consultant. He can speak to any of the FAA concerns. And then as noted in the November 24th, 25-day comment letter response to our response to our 25-day submittal, a number of agencies have already approved the project. Critical Areas has approved it. The APFS has been approved. Stormwater Management has been approved. Fire Marshal has approved it. And then really there are only some minor comments from Internal Critical Area, Planning and Zoning, and the Sanitary District. And as was shown earlier, the architecture meets the TCUC design guidelines. And that's about all we have. If you have any questions, be happy to answer them.
Are there any questions from the commission? I'd like to ask about that weather system monitoring station, whatever that's, AWAS, and the concerns that we have about that were listed in this staff report is that there are already moderate concerns from staff that it's already potentially being interfered with existing. And I'm curious as to why moving forward with this wouldn't exacerbate that concern.
Let me bring Dave Perry up, the FAA consultant, and he can speak to that.
Good morning. I'm Dave Perry. I'm a former FAA employee. I just recently got out of the FAA about 6 months ago, working with the Office of Airports, doing the OE/AAA stuff for airports in general across the country. So right now there's the existing storage building that's there is providing shielding from the current the storage facility there right now, and with addition to that, it'll still provide that shielding, so there'll be no issue with that. So that's one of the reasons why the folks at Tech Ops, which is when a notice goes into the FAA, there's 14 different lines of business that look at those, flight procedures, air traffic control, techno-co-ops, even Department of Homeland Security. Everybody looks at all these different cases and they provide their responses back. So Tech Ops looked at this, looked at the existing buildings, looked at the structure where it's at currently, and their evaluation and all their tools that they use to come up with those, either a positive or a negative result. They used that and found that there would be no issues or no hazards to air navigation for the AWAS antenna, that it would still work as described.
I'm not at all any more enlightened than I was when I asked my question.
So, I mean, there is siting criteria.
Correct. So there's concern that we have internally about its current location. We're about to develop next to it. I don't know why you're bringing Tech Ops into this, but the concern is that the county has expressed concern that if this weather system needs to be moved because of an outstanding report that's due from the FAA, this petition says it has to be moved. So now it has to be moved. Where do we move it? Is there potential that it has no place to go, and the county's on the hook for moving that potentially? Can you address that? What if we make this, let's hypothetically for a second here, we approve this with the contingency that in our staff that you have suggested that you will pay for the relocation. Fantastic. That will be a contingency as we move forward if that's the case. What if that system has nowhere to go and it can't be moved and you've painted yourself into a corner by building this building?
So based on the feedback that we've received from FAA to date, we do not believe that that's going to be the case. So we believe that the petition will be re-reviewed. They will stand by their original determination, and which states that the AWAS can stay where it is and these buildings can be erected with no significant interference with the AWAS functionality. So,
But that's a presumption you're making in the absence of that in writing,
well, that's the
correct?
condition of the approval.
Right.
Correct.
Yeah, a presumption we're making based on them having already approved it and said it doesn't affect it. They've already done that.
Well, heaven forbid the government change their mind.
That's possible.
Right, okay.
Yeah.
So I reached out
I'm
to
just
the-
laying out
yeah.
my
Yeah.
concerns
No,
and
I-
concerns expressed by others up here.
Yeah.
Mr. Showalter, you're sitting on the edge of your chair. Would you like to comment?
The only other thing, Mr. Lee, just to clarify from Mr. Perry's comments, Tech Ops is the division of FAA that reviews the AWAS and makes that.
Has nothing to do with the next
Not the
application.
next application,
No,
correct.
that's right. So I
Thank
just
you
wanted to connect
for,
those
thank you
dots.
for clarifying.
And I reached out to the manager at Tech Ops yesterday. We're really good friends, and we worked together constantly for the last 3 years in FAA. And he said, we absolutely are going to uphold exactly what we provided in the determination of hazard letter. The petition has to go through the whole processes, and it's sitting in its initial spot where when the airport filed it, it's taken forever right now for the FAA to get the things and start the processes. So, but they've already done the evaluation again and confirmed that and provided that findings back to those individuals already. It's just now was the time frame to get the petition working through the process and back out to the airport.
And if it has to be moved, any ballpark figure on what that dollar bill is, what that estimate
No,
would be?
sir, I don't.
I mean, has it been moved before?
I don't think that's the original spot that it is in right now because I've worked on multiple projects around here, and I don't think that's, looking back from years ago, it wasn't in the spot that it was.
I don't know.
I'm not sure exactly where it was, but I think it's been
I'm a
positioned
pilot.
there.
I use that airport, but I
Yeah.
don't remember if that was, like a new spot or if it was somewhere else back in the day. I'm not sure.
But no,
Yeah.
not even a ballpark you can give me.
No, sir.
Okay.
I mean, because the current location of it right now is, 20, 30 feet away from a hangar, so I'm not sure why they picked the spot that they did when they put it there, with the requirements of, the 500 foot, the 1,000 foot and elevations and stuff like that. But again, Tech Ops looked at that, I'm sure, when they filed for that hangar, and they determined where the antenna would be and where it'd be located would not cause any issues, so.
Suffice to say, it's probably not small. I'm right. I mean, it's expensive equipment and infrastructure
I'm not sure if
involved.
it's millions. I'm not sure exactly how much it would be to move the antenna. Again, you would look for a spot and try to see, is there a 1,000-foot circle somewhere that we can go? If not, then where can we go down to, and what the height we'd have to make in order to get over top of any existing structures and within inside the area.
Are we talking about an antenna or the sensing apparatus?
It's the sensing thing on the top, sir. It's the
Okay.
antenna, but it's the sensing on the top
Right.
that we'd be talking about.
Super nice weather station.
Yes, sir.
Measure that you can say whether it's functioning now worse than it was 3 months ago. So I would entertain some additional conversation about how we can word that.
Just read that real fast.
Can you say that again, because it took me a little while to find the page,
Yeah,
I'm
let me,
sorry.
it's.
Looking at number 8.
It's number 8. Pending the outcome of the FAA review of county's petition, the developer shall be responsible for all costs necessary to restore full functionality to the AWAS in the event it is impacted. This may include the relocation of system components or the entire system as determined necessary. So, I guess it depends on what they come back with from the petition. If they do not stand up to their original determination and they want it moved, then that would be Hinckley's call whether to move forward with the project. If they say, we stand by our determination that there's no hazard, and Hinckley builds their facility, there shouldn't be a mechanism that's not measurable, that somebody comes back and says the functionality has been decreased. Because it's just it's a weather station that's measuring airspeed, essentially, in direction.
But, so I would add, the condition is really refined to the county's petition. So, and the way that it's drafted right now, it says pending the outcome of the review of the county's petition, so not after the fact. So they would have to determine at time of reviewing the petition that would have an impact in order for you to have to pay to move it.
Not be ongoing.
Correct.
Okay.
The way that it's drafted, as I read it.
Well, and so the only other clarification is, to the extent there's some determination it's impacted.
I'm sorry, Ms. Show, can you get on a mic? They're gonna, thanks.
So the only other concern I would have is, to the extent it's determined that it is impacted today, if the existing building impacts it, we don't think it should be our obligation to move it today, to restore its full functionality. It's only if this building, this project causes an impact that requires it to be moved.
So you're forecasting possibly this determination says it's already impacted.
Well, I mean, what
It's a
what I think
possibility.
the FAA told us before was it didn't have to be moved. And I think Mr. Perry's testimony was Tech Ops has already confirmed that determination again to him verbally and said, we won't require it to be moved.
It's, even if it's moderately, de minimally impacted, at this point, that's fine with us. Is that what
Well,
I'm?
I think the fact is that they've said it's not gonna be impacted at all.
It doesn't have to be
Am I
moved.
correct, David?
Yes, sir.
Yeah.
In its current location?
Yes.
So it would be,
And that's what
the
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 determination.
presence of your building that you're proposing would be therefore the impact if that changed.
If that changed, that's
Yeah.
right. So
But-
so again, if it's linked to the petition, if they say it has to be moved, we understand that condition. But we don't want to be in a position where there's some ambiguity about restoring full functionality in a debate of what full functionality means and whether
How
we're
you measure
responsible
that
for.
and, yeah.
Right. It was written and tied to the petition as it states. I mean, it says quite clearly, pending the outcome of the FAA's review of the county's petition. If the petition says, hey, this new structure is going to cause an issue, well, then they're on the hook. If it gets built and then there's an issue, well, I don't know what that answer is, but that wasn't with the petition.
Okay.
I wrote it, and that's the way my intent was written, and I think it quite clearly reads that intent.
I agree with that.
I think the record's clear based on the discussion. So if that's the intent, I think we're okay.
And you're willing to take on that risk, not knowing how much it costs to move it? Still?
We're going to have that answer.
You're hedging that there will be no change. You'll make it a positive determination.
Or we could not go forward with the project.
You pull the plug on the project.
Yeah, that's an option as well.
Do we have any sense of how long it takes to turn these petitions around? I mean, are we waiting months? You have machines running, waiting for this thing, or what?
Well, right now, I think everything's about 3 times as long with inside the FAA just to get a normal determination if somebody wants to build a house or an antenna. Normal timeline to get a response back from FAA is 45 days. That's up to like 120 days now. That's because of me and tons of other people left the government. And even before that, there was a lot of changes and a lot of folks gone that just exacerbated the timelines. So to me, I think the airport might have filed this probably at least 2 months, probably 3 months ago, the petition, and it's still sitting in the same inbox and nobody's touched it. That's kind of alarming, especially for a petition. They want to take those, and that's like almost number one action. Let's look at these and see if it's first one, is it a viable petition? If it is, then they go out to the lines of business that would work this, which would be Tech Ops, and they've already kind of reached out and done that part on the side, and they've responded back to them with it, but the petition itself is still sitting, waiting to be even looked at. So I would hope within the next few weeks that they would actually take action on it and start the process, so.
But to answer your question, no, we don't have machines running, but time is very, very much of the essence. for
Probably
us.
looking to start in the spring or something.
Well, fall. We would like the building to be complete end of November, say. Our business is very seasonal, and we've made a lot of arrangement and investment to move employees up here. So eventually this facility will have, 20, 25 employees who are all, really skilled craftsmen, like highly paid carpenters, electricians, those people who work on our boats, because our boats it's a sort of a high-end luxury brand. So we've made a lot of investment in technologically and everything else with HR in getting those folks, ready to report up here. And we really don't want to miss like a whole season, so time is definitely critical.
Hence, you're moving forward without that in hand already.
That's right.
Bill, do you still seem like you have reservations or questions, or you
No,
still?
I think they've done a pretty stellar job, and that they're awake, right? And at risk for them, Yeah, I think so.
I have a question for
Go ahead.
council. So, I understand, in in number 8, in the event it is impacted. Because for me to clearly know what I'm voting on or reading here, it is impacted by this project.
Correct. So the way that it is drafted, it's pending the outcome of a review of the county's petition. And the county's petition that is currently pending is specific to this project. So really, the onus is on the FAA to determine at this point whether it would impact or not. And unfortunately, if they fail to do that and there is an impact, we're kind of out of luck with the way this is drafted. But hopefully, it's undergone substantial review and they can make that determination at this time.
Thank you.
Anything else from the commissioners? Nobody online, right? Do you have any public comment, Bruce? Nobody online? John, nobody signed up
The only person that had signed up was Mr. Falstead.
for
Let me check
this particular application? Anyone in the room wish to make public comment while we're digging up that?
No one signed.
No one else. All right. Is that all from the applicant?
Yeah, just as far as the project schedule, I would like to thank the county staff for moving this along, because originally we were gonna be on a January planning commission agenda, but they worked diligently, and we appreciate that got us on the December agenda.
Duly noted. I'm sure they enjoy hearing that, though. Thank you.
Yeah, that's correct. I have substantial experience doing this in Florida, and the staff was very professional.
Good to know. That sounds like workers' comp. You be careful. All right. No other questions from the commission, none in the public. I am open, the floor is open for a motion.
Mr. Vice Chair, be it resolved that the Planning Commission regarding the request by Hink BB Holdings LLC for major site plan approval to administratively combine 3 lots to construct a 47,067 square foot addition to an existing boat storage and maintenance building, and is more particularly described in Department of Planning and Zoning File SP number 25-08-0158, hereby finds the site plan does meet all requirements of Chapter 18, will not substantially increase traffic hazards or safety concerns due to traffic generated by the proposed use, the location or orientation of curb cuts, or the layout of internal circulation, does contain a layout of buildings, parking, roads, and utilities that does not substantially increase fire, health, or other public safety hazards, is adequately buffered and screened to minimize potential adverse impacts to neighboring properties and public rights of way, will not substantially increase stormwater drainage or pollution, will not have an unreasonably adverse effect upon property values in the vicinity of the site, will not adversely affect the public welfare, and will provide for public safety through compliance with the state fire code and with any applicable county or municipal fire codes, is compatible with the general character of the surrounding neighborhood, and is consistent with the purpose, goals, and objectives of the 2022 Comprehensive Plan, and hereby grants major, this says minor site approval?
It's supposed to be
Major
major.
site plan approval.
Okay.
Apologize for that.
No, it's fine. And hereby grants major site approval, subject to the following conditions. Number 1, all remaining edits and/or documents required by the Department of Public Works, Planning and Zoning, or any other reviewing agency be reviewed and approved. 2, all remaining comments, edits, and/or documents required by the Maryland Department of Transportation, State Highway Administration must be addressed. 3, all required legal documents must be approved, signed, and recorded prior to obtaining final site plan signatures. 4, prior to final site plan signatures, recitals within the critical area buffer management plan maintenance and protection agreement shall be amended to accurately reflect the new owners and the revised lot configuration. 5, all required bonds, sureties, review, and inspection fees must be submitted to the Department of Public Works and the Department of Planning and Zoning as appropriate. 6, the project must adhere to all applicable regulations established by the Maryland Aviation Administration and the Federal Aviation Administration. 7, prior to final site plan signatures, all remaining airport-related comments shall be fully addressed to the satisfaction of the airport manager. This requirement includes but is not limited to all conditions identified in the attached Airport Manager Review Number 3, email dated November 24, 2025. Number 8, pending the outcome of the Federal Aviation Administration's review of the county's petition, the developer shall be responsible for all costs necessary to restore full functionality to the automated weather observation system in the event it is impacted. This may include the relocation of system components from the entire system as determined necessary. 9, the conditions specified in the letter from the APFO administrator dated November 21, 2025 must be met. 10, the administrative subdivision must be recorded prior to final site plan signatures. And 11, the architecture and overall site design must substantially reflect the documents provided.
Rather lengthy motion. We have a second by Mr. Tillman? No. That was by Art. If there's a motion, there's a second. All those in favor?
Aye.
Any opposed? Any abstentions? Motion carries. Thank you.
Thank you very much, gentlemen. Ladies.
Have a pleasant holiday season, gentlemen. All right. Next item up for bid, concept plan SP 25-08-0159, Reliable Development Company LLC, AKA Tech Ops Specialty Vehicles HQ. That's also you, Mr. Johnson?
Yeah, you get a full day of me today, unfortunately. Everybody ready? Okay.
All right,
Yeah,
Steve, floor is
yep.
yours.
Thank you. As stated, we're here to discuss project SP number 25-08-0159 for Reliable Development Company LLC, who's proposing to construct a 40 square foot building for the design and fabrication of specialty vehicles and is requesting concept plan approval. Project is located in Stevensville, south of Route 50 and east of Pier 1 Road, directly behind the Target. More specifically, tax map 56, parcel 20, lot 109, totals 4.411 acres and is located off of Ellendale Farm Lane. As you can see by your aerial on the screen, it's currently used for agricultural production. The Target is the large white building that you see on the right. Property is zoned urban commercial and it's located within the Chester-Stevensville growth area. The property is also located within the priority funding area, which is not shown on your screen. Property is partially located within the RCA designation of the critical area. This is the dark green sliver of the property on the right side of your screen. That area is subject to an easement that limits its use to passive recreation, planting, and landscaping not associated with the proposal. So this proposal cannot encroach upon that area and does not. Conceptually, all Chapter 18 landscape requirements are met with this proposal. That includes on-site, buffer yard, and parking lot landscaping. There are 0.189 acres of non-tidal wetlands and 0.52 acres of their associated buffer on site. These are the bright green areas at the center of your screen. The applicant is proposing to disturb 0.188 acres of wetlands and 0.435 acres of the buffer. MDE authorization for this disturbance is required at site plan. There are 0.40 acres of woodlands on site, in which the applicant is proposing to clear 0.15 acres. Those areas of clearing are delineated on your screen in the hatch white and brown. Forest conservation was addressed with the original subdivision, and there are no steep slope streams, erosion hazard areas, endangered species, or 100-year floodplain on site. Conceptually, all UC district non-residential development standards are met with this proposal. That includes height, setbacks, floor area, impervious area. Again, the applicant is proposing 40 square feet of floor area and 107,791 square feet of impervious area, which are well below the maximum permitted on site. All Chapter 18 parking requirements are met with this proposal, and stormwater management will be provided on site. Those areas are shown in the bright green hatched areas, and DPW will continue their review through the site plan process. Again, public water and sewer is required for this project as well. The applicant must file an application to the Sanitary Commission for the necessary allocation to serve the project. APFO is not required at this time, but must be addressed at site plan. And with regard to the airport, there is an overhead flight easement that runs through this property, which restricts structures and plantings to a maximum of 35 feet in height. This project complies with that restriction, as the proposed structure is proposed to be 34.8 feet, and all plantings will be below that maximum permitted. Again, the airport manager supports conditional approval of this project, subject to the conditions included in the staff report. Here's a look at the renderings of the building. These do meet the TCUC design standards. This is the view from the entrance looking south. The view looking towards the northeast. This is a view looking towards the northwest. And finally, this is a view looking towards the southwest. And with that, I'd like to wish everybody happy holidays. And if you have any questions, I'll try to answer them, or I'll turn it over to the applicant.
Any questions of staff?
There you go. I forgot this slide. There you go.
Oh, there you go.
Rob went to all that hard work. I better put it up there. I apologize, Rob.
Any questions of staff before we go to the applicant?
Yeah, I asked, how's the farm get access now? You took the lane out.
Right now, I think they come through Ellendale Farm Lane, from what I understand.
Pardon me?
How does a farm get
How's
access?
the farm get access now?
Through Ellendale Farm Lane, I assume. Is that accurate, Nate or Dorsey?
So they come through your property to get to the farm? Is that what you're saying?
Are you talking about the farm to the rear?
property,
I'm talking
the
about-
county
After,
farm.
after
Yeah.
development,
Farm.
how does they access the farm?
They have, if you look further to the south in the bottom left corner of that screen, that's the old Kent Manor Drive Road, and that's how breeding gets in there to
Okay.
access. There's that little sliver kind of that runs
I was sure
parallel
it was
to it.
thought out, but I still wanted to ask.
I thought you meant this
Of the
parcel. You're
farmers. So why are you taking out the woods right there at the entrance there, that odd-shaped piece of woodland?
Talking about the part that shoots into the left?
The hatched portion.
Yeah.
Yeah, the hatch part, yeah.
The one that goes up, like oddly up,
Yeah, it's kind of weird shape.
it connects to the water or sewer, which.
Oh, that's your access corridor through that wooded lot to connect to infrastructure?
Yeah.
I was gonna ask the same thing, Bill. It's just an odd looking,
Well, do you
clear
have,
cut.
do you have to mitigate those trees you take out?
No, we don't. We're just doing the landscaping on site, what's required.
Forest conservation was addressed, so they have no further requirements.
Okay.
Yeah.
All I got.
All right, any other questions before the applicant goes? Whoever's driving the bus, hop on board.
Nate Hoxter with Lane Engineering, John and Dorsey. Steve, thanks for, introducing the project and, providing the review. I don't really have much to say on, the project, as Steve covered a lot. So.
And just to add to it, John Brannis here is with Tech Ops President, so he can answer any questions you have about operations and kind of the plan for the actual building. And then we also have Mark Keeley here from Traffic Concepts to answer any traffic impact questions. And then I'm with the applicant developer, Reliable Real Estate Services, agent of Reliable Development Company.
Questions of the applicant?
This is essentially a manufacturing operation, is that correct?
It is.
Yeah, so the traffic then would be a shift change,
Employees, we currently run one shift.
okay? And that would so be, I was thinking about the traffic trying to get in and out of Target and that intersection, ironically, across the street is Hinckley. And we're confident that this isn't going to produce any sort of bottleneck or anything.
Correct. And Mark, if you want to chime in on that.
Yes, Mark Healy with Traffic Concepts. So we did a full APFO traffic impact study. We looked at the eastbound and westbound ramps on the interchange, Route 8. We looked at Maryland 8 at Thompson Creek, Pier 1 Road. We looked at the roundabout on Thompson Creek and, of course, the access to Thompson Creek. We utilized the critical lane analysis, but also for the signalized intersections, we use the highway capacity software, which we're not required to do, but it provides a more detailed analysis of each movement at the intersection, and the analysis indicated that all intersections would operate at C or better levels of service.
Thank you.
Any other questions of the applicant?
Yeah, I've got one. So we got a letter this morning from somebody talking about the historic value of that property. So I'm gonna ask about that.
Yeah, I had just gotten a text, maybe, while Hinckley was going on, with kind of a picture of that letter, and that was news to me. Through the county staff review and the historic, what's the department that reviews historic significance?
Maryland Historic Trust, MHT.
So through that, there was nothing brought up. From the quick reading of that letter, it mentioned that it was a parcel, part of an old thing. It's nothing that we've been aware of, and really every parcel on Ken Island that's existed has been part of a historic at some point. It's kind of in its nature.
How many employees will you have? Just curious. Can I ask that?
Sure, that's fine. Yeah, we're mid-40s right now. We have remote employees, some of the engineering staff and sales staff.
If I ask you what you're building, will you have to kill me?
Not necessarily, although there are sensitive projects we can't talk about.
What do you build?
We build vehicles for the government. It's a variety.
Military?
We do.
Okay.
Yep.
All right.
A lot of homeland security. Think, specialty vehicles is a broad range, a spectrum of stuff. We do very simple things like library on wheels, bookmobiles, which bring books to rural areas and families and kids that wouldn't otherwise have access. We also work on programs of kind of highest levels of national security.
And are you relocating from another location, or is this an expansion?
We're in the business park in Log Canoe Circle right now.
Okay.
We've simply outgrown it. We're, pipeline of new programs and future projects. We've grown 3 times since it's been there in 2006. And some of the, upcoming projects just require more space. The building itself will give us, more than twice as much capacity of production as what we currently have. We're, didn't get a chance to just kind of say thanks to the planners and, Rob and Steve are up front, but, we're really excited to stay in Queen Anne's County. The business has been there since '06, not originally called Tech Ops Specialty Vehicles, but it's grown throughout the years. It's really a great spot, to kind of service our federal customers and visits and progress visits as we move through construction of vehicles. But then also from a labor and workforce perspective, it's a nice central spot close to DC. We pull from the Western Shore and the Eastern Shore for our labor force. And we feel like that's important in the long run for the business. And to be able to find a spot here that's in the county, I think is important for us. And it's, KRM's been great in the Log Canoe Circle park, but we're just outgrowing it. And we are all Maryland owned. The business is Maryland owned, veterans as well. So it's, that's an important piece, I think, to stay in Maryland as well.
Any other questions regarding? I got a question back of Stephen, just to be clear about this, the letter of opposition for Mr. Lynn's. There were no historic findings from MHT. It's simply the fact, like, there were no buildings being erased, there's no burial grounds on site, there's nothing odd sticking out that we missed? Okay.
Yeah, when we take this for completeness, we bring these projects in for completeness review, we look at that, we take a look at whether or not there's heritage sites adjacent to it or nearby, and there were none shown.
Okay.
So it was not even sent for review.
I just want to make sure that was clearly stated. Anything else of the applicant? All right, is there any public comment online? We have somebody in the audience. Sir, please come up to the microphone on the podium there and introduce yourself, please.
My name is Loring Mills. I live at 232 Topside Drive, which is within a mile of this location. That intersection between Route 8 and the runoff to Target is a very busy place. There's left-hand turns on that lane coming south, and the congestion there is significant now. It is hard to understand how this is going to be non-effective, even at any time. Making a right-hand turn off of Route 8 going towards Target is a challenge now. And I question the concept of the road people saying that there is no effect here. It is a significant effect. Also, I'm somewhat concerned safety-wise of stormwater management. As we all know, and a lot of effort has been put into, Kent Island being a very flat area, we have stormwater problems. We have stormwater from commercial units and industrial units flowing into residential properties. A lot of it is antiquated. It's been put together in a fragmented way. And I believe it's very important for us to do a major review of the stormwater runoff, stormwater management of this whole area, including the one for the project you discussed earlier. That quadrant between Route 8 West and Route 301 South is made up of a combination of stormwater management concepts that have developed over years, and they're out of date. A major effort needs to be applied to that particular stormwater management area. Thank you.
Thank you. I'm sure those points will be well addressed as we move from concept into site plan approval, but duly noted, sir. Thank you for your time. With respect to the comment about ingress and egress into the property, I noticed in one of your pictures you said, some larger scale tractor trailers. Have you thought about how the movement of these larger vehicles in and out of property may impact, and what are your thoughts on that traffic patterns as they leave and come into and exit your facility entrance? Like, how do you propose a tractor trailer makes a left-hand turn, or are they going to make a right-hand turn going down to the traffic circle?
So the site access will be designed as a commercial entrance. We can provide auto-turn software that shows a tractor trailer entering and leaving the site. So the traffic study was submitted to SHA, and we did get comments. So
It's more of a question that have solidified by the time you come back in for site plan approval, is that, as we look at things like mines, extraction properties, we have a detailed routing of where trucks are asked or required to transit the area to avoid sensitive areas or bus stops or other infrastructure. So if that could be made part of your next submission, I think it would be appreciated that we show that trucks of a certain size go one way, not this way, or at certain hours it's okay, whatever that looks like. If you could have something that addresses those concerns that were brought up by testimony and the commission as well, that'd be helpful.
Okay, we'll do that.
Anything else from the commission? Any more public comments? Bruce, anybody online?
People are online, but no one's told me they want to speak.
Got it. Fair enough. All right, the floor then is open for motion, should anyone have one to make.
Mr. Vice Chair, be it resolved that the Planning Commission regarding the request by Reliable Development Company LLC for concept plan approval to construct a 40,040 square foot building for the design and fabrication of specialty vehicles within a 4.411 acre parcel in the urban commercial zoning district, and is more particularly described in Planning and Zoning File SP-25-08-0159, hereby finds that the concept plan is consistent with the goals and objectives of the Queen Anne's County 2022 Comprehensive Plan. The concept plan is consistent with the Queen Anne's County zoning and subdivision regulations, and hereby grants concept plan approval subject to the following conditions. Any remaining edits and/or documents required by a reviewing agency, the Department of Public Works, or Planning and Zoning be reviewed and approved. Prior to the submittal of the major site plan, all remaining airport-related comments shall be fully addressed to the satisfaction of the airport manager. This requirement includes, but is not limited to, all conditions identified in the attached Airport Manager Review Number 3 email dated November 24, 2025. And the architecture and overall site design must substantially reflect the documents provided.
Second.
A motion, there's a second. May I also ask, if council, if we would probably prefer, I think I know the answer to this, to select any other findings of fact from the report. Can we reference that, or should I suggest that the amendment be amended? Motion be amended.
That the motion be amended to include specific findings from, is that your question?
Correct. Are you comfortable with the motion that as made, or should we include findings of fact from the staff report?
I would appreciate if you would include findings of fact from the staff report. You could make a motion to amend, finding that you reviewed the staff report and find that the findings made within it are consistent with your review and what's been presented this morning.
I'd like to amend my motion in the language provided by council.
Fair enough, there's an amended motion. Second. We have a second. All in favor?
Aye.
Any opposed? Any abstentions? Thank you. Congratulations. Look forward to seeing you in the future.
Just real quick, I think we just approved, two companies gonna create 70 jobs in this county.
Well, one's moving, so not necessarily creating new,
But
but
he's adding two, aren't you?
you're growing.
Yeah.
Keeping it.
Congratulations.
Up to 45. Don't say no.
Clear some space in the business park.
Right. All right, let's, tell you what, let's take a 5-minute recess for a break before we come into our third and final conversation topic, please.
I do want to announce before we get into the next project, if we could go back to legal updates. There is one legal update that I failed to mention, but we can take the break. I'll do
Start
that when
with
we come
that.
back, and then we'll add the project.
Fair enough. All right,
Thank
5-minute
you.
recess. We'll start with council. Ms. Ryan?
Yes. So I failed to mention earlier in the agenda for an update on legal matters, there was a pending case, Queen Anne's County Conservation Associates, Inc. versus Queen Anne's County Board of County Commissioners. This case resulted from the commissioners' vote to reconsider Chester Haven Beach's comprehensive rezoning request to include Chester Haven property in the Chester growth area in 2024. In November of 2024, Queen Anne's County Conservation, which was later also added Critical Area Commission, filed a complaint alleging that the action was illegal. The Critical Area Commission also argued that the action was illegal and void because the commissioners failed to provide notice to the Critical Area Commission before processing the rezoning under some of the provisions of the Natural Resources article and the Land Use article. On December 5th, the circuit court agreed with the plaintiffs, unfortunately, and found that the rezoning of the property was denied in 2022 and considered again 2 years later, which fell outside the statutory timeframe in which the commissioners had to adopt, remand, or modify the comprehensive plan, which provides a 150-day timeframe from recommendation from the Planning Commission. In addition, they found that the county failed to provide notice to the Critical Area Commission. So that decision has been determined to be void, and at this point, the county has, and the other party have 30 days to file an appeal of that decision. The county can, of course, take no action, or the county could decide to go through the amendment process all over again with a comprehensive rezoning amendment. I don't believe any decisions have been made as of right now. The decision just came in last week.
You said 30 days from that?
Yes.
Got it.
From December 5th.
From December 5th. And is that all you had for legal updates?
Yes.
All right, thank you very much. Now turning to the next item on the agenda, major subdivision amendment to covenants, ATE number 25-10-0013, parenthetically sub number 105110007, Meadow Creek. Councilor Lindsay Ryan has the floor.
Yes, so this project is a little bit unique from one that you have seen in the past. This stems from a 2006 Meadow Creek subdivision, final subdivision approval that created an 18-lot major subdivision. As part of your Queen Anne's County Code, section 18.1204, it requires that subdivisions have covenants that govern the uses and lot size and natures, kind of like an HOA. So for this project, there are 18 lots. The covenants were recorded they were approved in 2006 and recorded on the same day. Under your Queen Anne's County Code and a note within the covenants, these covenants cannot be amended or changed in any manner without prior approval from the Planning Commission. And so what is in front of you this morning is a request to remove Lot 6, which is one of the 18 lots that were subdivided as part of this, from the covenants. Lot 6 is 32.067 acres, and I don't know, Steve, if you can show where it's depicted somewhere on.
It's the highlighted red area.
Perfect. It is shown in that highlighted red area. The purpose for removing it from the covenants is so that it is not subject to the restrictions that are in the covenants. I believe that the contract purchaser or potential purchaser would like to keep livestock on that parcel, which is currently prohibited under the covenants. And so you all have to consider the request to amend the covenants to specifically remove that lot from the restrictions in the covenants. There's no real standards by which you would review that, but what you should do is consider that it was approved at one time as part of a major major overall subdivision request with covenants, and whether removal of this lot from those covenants would impact, you know, the overall major subdivision that occurred back in 2006. And I think the applicant is here and can add some more information. I do want to stress the importance that if this Lot 6 is removed from the covenants, while the intent is to use it for livestock, it could be used for any purpose that the code currently allows in the agricultural zoning district. So you're removing it from any of the restrictions that are currently in the covenants that the other 17 lots are still remaining subject to.
I have one question. Would the abutters, in other words, the people in these houses that this lot surrounds, if they have objections to reverting to agricultural use, is that any of our business, or is that business of the homeowners association or the covenants?
So they could certainly come to this meeting and object to this being removed from the covenants, but at this period in time, how many lots are in there that are actually developed?
I don't believe any are at this point. I think they're all still owned by the developer.
So at this point, no lot owners would have the
Okay.
authority because the declarant is still the only individual with the authority to amend the
So
covenant.
no improvements have been made to the current lots as we see them? No houses, no buildings?
Not to my knowledge.
There's one model home, but we are the first one to have any sort of contract on any of the properties in the development.
And you're the owners of this Lot 6?
Potential owners.
Sorry,
Potential
we'll
owners.
introduce. I'm Genevieve McFarland with Stevens Palmer. I'm representing the contract purchaser. I have Mika Koivula, who is a contract purchaser of the property. Lindsay Dixon through Meadow Creek LLC is the current owner. Unfortunately, he couldn't be here. I know he had sent a letter in support that should be part of your packets.
Oh, you're in the enviable position of being there first, and subsequent owners either are or not, or buyers are or not apprised of the fact that there's going to be agricultural activity there.
So I would like to add that this is already in the agricultural district.
Right.
It's part of the
Understood, yeah.
comprehensive plan. It's, compliant with the comprehensive plan, as well as the priority preservation area, which certainly stresses the importance of agricultural use of the property in the county.
I would say that horses are probably a lot less intrusive than a combine doing soybeans, for those of anybody that lives next to a soybean field knows, so,
Less dusty.
yeah.
Yeah, and I think, at least in my mind, it's a little different as opposed to this development being half-built.
Well, that's what I was
And
driving
people
at.
signing on for something totally different, and then all of a sudden they get short-sheeted.
If there were residents, I would like to hear from them, but I also question whether that's really any of our business, given the covenants. I'm a little fuzzy as to how covenants work in conjunction with the zoning code.
Yeah, so for some reason, I'm not sure who drafted it, but Queen Anne's County specifically has a provision in their code that requires that for any major subdivisions, that there are covenants that are recorded, that are approved by the Planning Commission, and that any amendment has to come in front of you all. And I assume that's because at the time of considering the subdivision, you make sure that it's consistent with the county comprehensive plan, design requirements, the comprehensive plan, and then those covenants would tie into that consistency.
Would it be possible to do a development like this without covenants?
I don't believe, based on the Queen Anne's County Code, there have to be recorded covenants.
Okay.
I would note that the subdivision was approved, I believe, in April of 2006. Unfortunately, we don't have, I don't have the, minutes from that meeting as to why Lot 6 is so significantly larger than all the other lots. I think 16 of the other lots average a size of 1 1/4 acre. They're relatively small. As you can see, Lot 6 is large and kind of wraps around. It's still, would be a single-family home on that property, with a small farm set up to accommodate horses for their small children. Certainly adds to the agricultural aspect of the area, again, in conformity with the comprehensive plan. It's not going to be a soybean field, as you had noted, or, a large commercial operation. I would also like to note that working with council, we put together a draft deed, which would still subject this lot to the requirements under the platted subdivision, which includes, I believe, soil stockpile areas and required street tree plantings. So it will be subject to the design features in the subdivision lot, just not the restrictions of, no livestock being kept.
Will it require the owner of the parcels, Lindsay Dixon, to rewrite the covenants for everybody else now?
So we had also submitted an amendment to the covenants, so that would essentially exclude Lot 6 from the covenants. So it wouldn't require a rewrite, just the amendment that we had proposed.
And it's indicated here that from Lindsay's, Dixon's letter to the commission, that there's only going to be one home built on this 32-acre piece.
Correct.
Got a question for council and maybe for the applicant as well, sort of simultaneously. You brought up the potential that by removing this lot, we're subjecting or opening potentially other land uses on that lot.
Yeah, I mean, it could potentially be subdivided, provided that it meets other requirements. I think there might be some other subdivisions that it would meet, given the size of it, because it is 32 acres.
So if the applicant simply wishes to put livestock on the property, why don't we amend the covenants to allow that instead of opening the barn door all the way to other potential uses in the future?
So I think this is a question for the applicant, but what they had presented was an amendment to remove Lot 6. I suspect it's because the size and nature of the other lots that they don't want to subject the entire development to being allowed to have livestock. And
Well, that's my point, is why not just do that on Lot 6?
so you're
Everybody
saying
else, everybody else follows the covenants they currently have, they're bound to.
But for Lot
But
6.
for Lot 6, we remove that one piece versus opening it up to, up to other potential development land uses in the future.
Yeah, I think that's a question for the applicant.
Certainly, in the covenants, there are a lot other additional restrictions. There is architectural review, as well as and I don't know this exactly, but we had been talking about, requirements for how short the grass is kept and, those sorts of things that wouldn't necessarily be congruent with farm use of the property. Certain vehicles aren't allowed to be stored there, commercial activities, and obviously that's not the intent at this point. If there's some sort of, horse breeding operation, something like that, that could be considered commercial, just, looking down the line as to why it would make the most sense to take this entire lot out of those covenants.
I'm concerned about the precedent we're setting, right? And that this opens the door to others doing similar things. We've had this analogous conversation around some other developments and what they can be used for in the future. And it's the concern that perhaps the rest of the development is unattractive to potential homeowners, lot owners, because of that proximity to this proposed use, that they don't have any guarantee of what will be put there in the future, right?
I understand what you're saying.
And so as you suggest, there are other things that you'd like to exclude. Well, then, fine, let's draft a letter that says you can do this. You don't have to file, you don't have to cut your grass for 3 inches. You don't have to paint your fences white, right? So that we're protected from that becoming some commercial entity in the future, or,
Cluster
10 chickens,
subdivision or
10 chicken houses, or another cluster development without covenants, or covenants that are much less restrictive than the ones literally across the street.
Right. I understand you're concerned with the precedent. I will note that I think this might be the first time that you've had something like this come in front of you, because there is this specific provision in these covenants that this must be amended and approved by the Planning Commission. Many other developments have rights for amendment and that sort of governance within their communities. This is, giving that to the Planning Commission to make that choice before it is determined by the community.
Well, actually, there is precedent. Not too long ago, we denied an applicant their request to buffer, correct me if I'm wrong, staff, to install some buffer trees around the property because some of the existing homeowners liked the open field view. But there was a requirement or contingency, I don't know the exact verbiage, that required that to be the case. They came before us asking for relief of that requirement, and we said no, because we don't want to play this game, don't want to go through this exercise of piecemealing and customizing in such detail such developments, right? So there is slight precedent based on that we have denied that in the past, because we felt that that was a contingency of development, therefore it should be placed upon, which is where we are here. That contingency is on that lot 6, and if we take that off, we're contradicting our decision several months ago.
Sure.
I would suggest that since there's no lots have been sold, we're not, in your example, there were existing people, Tom, that, could object. In this case, they'll know what they're buying because this has already occurred.
Understood.
So it would be up to the discussion of whether they feel that they want to buy the lot or not buy the lot, with the knowledge that that property could become, as you're pointing out, something different than just a one-house, location.
Well, this is unique, Art, because I think you were yet on board, so let me back up just a minute to clarify. That situation I described, the analogy that I described earlier, there was no requirement to plant the trees at time of development, right? Essentially, it was once the last lot gets developed, this buffer of trees has to be planted. Well, we were at the sale of the last lot when this concern came up, and the people that had moved in liked the open view of the field behind their house, and we were coming in to say, no, you have to plant this buffer, developer, and they were looking for relief from that. So we actually voted against the current landowners, right? They got used to it not being buffered, and then they didn't want the buffer there that was required, and they knew about that when they bought. So it got complicated, and we denied that because we were concerned about the precedent that would set. Hence my question for council: why not go through surgically and put in language in that and adjust that the covenants to reflect that?
And as I had, noted, the 32 acres, having the autonomy to, run farm, certainly, again, subject to the design features of the subdivision plat, it would almost take a comprehensive rewriting of the covenants. It's, certainly a piece of property that would be better left to the ag zoning that it is. And, of course, if there was any kind of other development at that time or anything, if there are more homeowners, they can come to public hearings and speak out, just as we had, some folks earlier talk about their concerns. And, the Planning Commission or the Board of Appeals or whatever at that time can take that under advisement. At this point in time, the proposed use of the lot, the contract purchasers, and Mr. Koivula could certainly speak more to the plans on that, would be better suited to not have this type of restriction on it.
There's another large, very oddly shaped lot on the right-hand side. I assume that to be the east side. If those people wanted to have a farmette, as your client does?
I'm not entirely
Right?
sure about that one. I think, and I wasn't able to print out a plat that came out anyway. I could read.
Because the way I'm looking at, there's a really oddly shaped lot on the east side of this development. Yes, right where yeah, you got it.
I think that might be open space and
I don't have the plan in front of me.
I'm not entirely sure on that.
It is a for sale lot. he said.
There's no open
Okay.
space on it. There's the open space layer on your screen there.
Okay. Sir, you were standing up the podium earlier for public comment. If you've got something to add, please introduce yourself.
Yeah, I'm Bruce Orr, President La Crosse Homes. We do have a spec home up on Lot 13 currently. All the roads are in. They haven't been final top coated yet, but we are in agreement with the proposal to allow these folks to remove themselves of the covenants and restrictions due to the nature of that lot. Similarly, Lot 7, which is the other lot we're talking about, I believe when this subdivision was done, in order to get the density for the number of lots, they had to do the two larger lots to get the smaller lots in. So overall, per lot coverage, those two larger lots were needed to get the other 14 lots to be developed. So this is back, a number of years back, but I believe that was the rationale to why you have these two larger existing lots.
Very odd layout, actually.
Yeah, and as you see on this one highlighted, the upper portion of Lot 7 that kind of sits in between the lots is kind of, barely touching, but again, that isn't, more than likely will end up being an open space that's not necessarily usable for the person that purchases this lot. If you look kind of in the lower right-hand portion of that lot is where the home is sited to go, and the rest of that lot is kind of going to be open space. So similarly with Lot 6, the location for septic field and well is on the lower left-hand corner of this, and the remaining portion of that parcel is kind of, unusable space for really any development per se. So similar cases for both lots.
And all these lots are on water and sewer, or septic, rather?
Septic.
And one more question, please, to whoever feels more comfortable answering. This proposed Lot 6, right, the outlined in red lot, they will have access to existing roads?
Yes.
Okay.
So there's as you can kind of see coming into there's an existing farmhouse that's on the far, that there. So the road comes straight in and then loops around. Basically, there's a short cul-de-sac in between the lots 6 and 7, and then a turnaround at the very bottom of the site. So there's essentially two roads in the community.
Right, but that red lot, number 6, would have access to
Yes.
that road from their property?
100%.
Okay.
So if all the covenants are removed and the lot then becomes subject to Section 18, could someone put a solar array there?
Yes.
So from a point of view of the developer, perhaps they'd like to think about that, because I think a solar array next door to my house would definitely discourage me from buying a lot. Well, not definitely, but it's worth considering. To Commissioner Lay's point, would a more surgical approach be wise here in consideration of future buyers for the other lots? It's not really our business, but it's a marketing suggestion, among other things.
Sure, and I would note, to kind of ease that concern regarding a solar array, this is under contract. It is contingent on, it is under contract for a single-family home to be built, for a small farm to be built, contingent on this being removed, from the covenant. So the current contract purchaser has plans to be there long-term with their family. They have, 2 small kids that they want to be involved with the horses and, maybe some goats, and certainly live the Queen Anne's County, 4-H kid kind of lifestyle. And this piece of property, being able to have that as an agricultural property would certainly afford them that opportunity. I do understand your concern. I can say, the size and shape of the lot and the setback requirements for solar probably wouldn't be.
I understand that,
appealing lot, but I certainly hear your concern on
We're
that.
talking conceptually, and I said, supporting Commissioner Lay's point of view that something that's more explicit would perhaps serve all parties' interests better than something which simply says all covenants are removed.
Well, I don't think it's far out of reach, right? Don't those high capacity lines literally pass between this lot and the highway? Or at least in darn close proximity to that?
They do. There's a substation right to the north of this, and it was the subject of an inquiry about solar. But Genevieve is right. Conceptually, the setbacks probably would stop that, but in theory, the code does allow.
Would be small enough it wouldn't be attractive to a solar developer.
Yeah.
Certainly wouldn't be utility array, but still,
And I think from a perspective of the builder and developer, our prospective clients that are coming in and viewing this property are looking at the surrounding area. If you look to the right where the dark green is, where the chicken farm is adjacent to the parcel. So people that are coming to this area understand the nature of where they're looking. So in a sense of having something that's, more agricultural base is not necessarily a deterrent to someone buying in there. Most people that are coming and looking at this parcel are looking for something that has a little more expansive space. They don't want to be 40 feet from their neighbor. And so I don't think that having something that they're proposing would necessarily be a detriment to the folks that we're trying to sell a home to.
Not at all. I mean, I'm a big fan of agriculture. And to me, that's a plus. Maybe not downwind from a chicken house, but, you know, normal field agriculture, row crop, to me is a positive point. And having it as a livestock area, horse farm, great. I'm all for it. I mean, I like the idea.
If they're giving horse lessons to the neighborhood, then, you know, maybe that's a selling point.
What's your name again?
Mikhail Corvilla.
Kyle, how many horses you talking about?
Right now, 2. For my
Right
two-
now, what's the future plans? You gonna have 100?
No, they're for my 2 kids.
Okay. All right. As far as all the other discussion, I'm finished with you. As far as the other discussion with regards to how attractive or unattractive this development is, I think that train's already left the station. We're not doing that. The only concern I have is, as a board member, commission member, am I putting this commission and the county at risk by allowing them to change their covenants for one lot?
Yeah, so under your guarantees and covenants within the county code, it does say that for particular developments that require covenants, it has to include language that any covenant may not be amended or changed in any manner without prior approval of the planning commission. And so I assume that that condition within some covenants has been a deterrent for other developments coming forward with an amendment because you all ultimately have to bless it. If you do grant this, it could set a precedent for additional applicants coming in for you all to remove lots from approved subdivisions that are subject to covenants.
But the inherent in your statement is we have the right to change, to grant them the ability to change that covenant for that lot.
Yeah, so you don't have the right to grant it. It has to come to you for approval before they could undertake whatever other methods. Right now, only the declarant has the ability to amend the covenants with your blessing. If these lots were sold and there was an HOA established, the HOA would have the ability to amend the covenants, but still you all as the planning commission would have to give the final approval of that before it could be done.
Everything still comes back to us, whichever subdivision may make a request, it still would have to come back to us for blessing.
Provided that covenants are adopted consistent with the Queen Anne's County Code, yes.
So it's not like the precedent for someone else coming here doesn't change the fact that we already have a president that has to come to us. So it doesn't, this is just a one-off.
Yes, but future, I guess there could be scenarios where there are future subdivisions that are subject to covenants and then later, for inability to build or whatever reason, they then come to you and ask for certain lots to be removed from those covenants.
But based on its facts at that time that's being presented to us.
Right.
Right, and I would just like to reiterate the uniqueness of this particular lot in a subdivision that has a majority of smaller lots. It's, over 32 acres. It's in an agricultural zone within the comprehensive plan priority preservation area, which absolutely pushes the use of agriculture to preserve the character of Queen Anne's County. I would also note that folks moving to this area probably like the agricultural aspect, otherwise they wouldn't be choosing to live in such a rural area. So it adds to the character, it's consistent with the character of the zoning, and it is a unique lot in a subdivision. It's not, one of the 1.25 acre lots asking to be set aside so that they can keep a horse or two. It's, significantly larger than anything else. And worth noting again, it's still subject to the requirements under the subdivision plat.
So, question for the developer, sir, while you're still standing there. Any explanation as to why it's been 26 years you only have one spec house?
We actually just took control of the property within the last year and a half.
Okay.
So we are recent owners of the parcel. So once we had full approvals, did the infrastructure, then we put in the house. So the house has been up in construction, just finalized. Actually, I think we're going for UNO here in the next month. So, you know, we'll continue to build in there as we go along.
Any other questions of the applicant or staff? Is there any public comment? Anybody online? John, nobody? All right. Floor is open for a motion.
Mr. Vice Chair, it be it resolved that the Planning Commission has reviewed the request by Meadow Creek LLC for an amendment to the Declaration of Covenants, Conditions, and Restrictions for Meadow Creek that removes Lot 6 from the covenants, and hereby grants the requested amendment subject to the following conditions. Lot 6 must record a superseding property deed within the county land records, subjecting Lot 6 to all of the required subdivision elements currently located on Lot 6 that were part of the Meadow Creek Development Plan recorded at SM 3714 within the Queen Anne's County land records, and they must provide copies of this recorded deed to the Queen Anne's County Department of Planning prior to the issuance of any new building permits for Lot 6.
There's a motion. We have a second. Any further discussion? All those in favor? Aye. Any opposed? Any abstentions? Seeing none, congratulations. Motion carries.
Thank you so much. Mr. Chair, could I suggest that we review this provision in the county code that gets us involved in changing these covenants? I'm not clear in my mind. The motion carries. I'm not looking to change anything with that. But I am concerned about how this is going to impact our business going forward. And if we're going to get involved in these sorts of discussions for every change to every single covenant in Queen Anne County, I think it's going to be pretty cumbersome. And so I would like to suggest, and I'm perfectly willing to do the work on it, that maybe we examine in more depth how this works.
Would perhaps asking staff, when we have time on our agenda, to give us a workshop, presentation of
Excellent.
high-level overview of here's what we do, here's what you have in front of you.
Right.
So that everybody's a little bit more well-versed?
Yep. Staff?
You're the senior-most staff in the room.
Just say yes, yes.
Can we make, please, that recommendation of staff? John, you're taking notes, to have at an appropriate time in the agenda a presentation by staff or the appropriate jurisdiction authority on this to give us some sort of presentation on covenants in the county and development concerns that come up as a result, based on this example, maybe, and perhaps or perhaps and include perhaps this one and the one that we denied with that I used as an example earlier, so that we can sort of better understand this water in which we swim.
We can. Just to clarify, what you had denied previously with regard to the buffer is a completely separate code standard. That has.
That wasn't a covenants.
Yeah, so
restricted
cluster
covenants.
subdivisions, this one probably has it, I would assume. I haven't looked at this plan, but requires a landscape buffer around the entirety of the community. And there was a code section that said the Planning Commission could amend those standards, if you'll remember, to whatever you see fit. Everybody came in and wanted it reduced to nothing. We would go periods of time where there were no requests and periods of time where there were numerous. And it just so happened recently there were several that came in. Ultimately, the Planning Commission decided they wanted to look at the code. The code was changed, and now that is no longer available. This is a completely separate section of the code that doesn't get applied often. I've been here 18 years. I've only seen it one time. That doesn't mean that somebody watching this doesn't have an idea, and now something will change with that. But we can look into it. We'll report back to you and get you the information that you guys are looking for.
Excellent. Yeah, that'd be great.
Thank you for the discerning the difference between those two those two examples. Appreciate that. Anything else on the matter?
Just one question from here. Are you
Thank
going
you.
to tell her now or later she's got a job to do? Or are you going to do it later? Well, let her get her lunch first. Yeah, let her get lunch first.
All right. Is there any closing public comment from the gallery or online? No. Seeing none, do we have?